We're going to go ahead and get started. I want to thank everyone for coming. So my first thing is just a general welcome. And I want to orient us to this training. First, I just want to thank the San Francisco chapter of the National Lawyers Guild for helping us coordinate this really important training, and then also our panelists, Johnny, Golnaz, and Kyle, for making themselves available on a Saturday where a lot is happening, actually. And also all of our participants, people who are joining us for training. You could be doing a lot of other things right now, and we really appreciate you prioritizing this and making yourselves available for this 90-minute session. So the first thing, I just want to introduce the National Lawyers Guild. The National Lawyers Guild is the oldest progressive bar association in the United States. We have chapters across the country, and I'm here as a representative of the Guild. I'm the co-chair of our Palestine subcommittee for the national organization. And this training was also put together with coordination from our San Francisco NLG chapter, which we're really thrilled to work with them. The purpose of this training is to really equip lawyers with the skills and tools to mobilize quickly. As I think everyone on this training is aware, we're in some really dire moments, and we really need our attorney corps to sort of mobilize across the country for rapid response. And so we really wanted to make sure that lawyers who are either already working in the immigration space or are interested in getting more engaged in this space are given sort of an overview training on habeas. And before we get started, I also just want to say, if you're not a National Lawyers Guild member or you're not a member of your local chapter, I want to highly encourage you to do that, because in terms of rapid response for mobilizing lawyers, our local chapters and our committees are really helping to coordinate that response. So regardless of if your capacity is huge or small, there's always a way for you to get involved. So with that, I just want to introduce you to our panelists. So Golnaz Fakhimi, she's the legal director for Muslim Advocates. She's bringing a lot of experience to us in this webinar, and we really appreciate her being here. Kyle Barron is an attorney who challenges immigration detention and deportation in federal courts. She's worked on some of the really high-profile cases, and she's very well versed in habeas, so we're really excited to have her with us as well. And Johnny Sinodis, I'm sorry, is a partner at Vander Hout LLP in the Bay Area, and he practices removal defense, appeals, immigration consequences of criminal conviction, so also very well placed on this particular subject matter. And so we're really excited to work with them to get this wealth of information from experts in the field. With that, I just want to kind of orient us to this particular moment. So, there's a lot of movement work happening right now in the context of authoritarianism, fascism, and general unrest. And we are seeing the weaponization of immigration law to be used against people to really target people based on other fundamental rights and constitutional rights. So I think it's important for us to understand not just what habeas is, but also that habeas is a tool that actually is fundamental to fundamental to US democracy, in quotes, right? And that it actually predates the United States, and it's a well-held doctrine that's been established since 1215. So this is not a new area of the law. It's existed longer than this country has existed. There have been a lot of actions taken across, US history in order to narrow the scope of what access to habeas looks like. And even most recently, Steve Miller has made some very specific statements within the last couple of months on trying to essentially eradicate access to habeas corpus as a tool. Habeas, effectively is what is used to make sure that the government cannot overreach by detaining people without due process and just cause. So I don't want to take away from the time we have for the training. So with that, I'm going to go ahead and hand it over. And once again, thank you for joining us.
Thanks, Leah. Nice to meet you all. I'm Johnny Sinodis, as Leah said. This presentation, I think, is very timely. There are a lot of arrests happening throughout the country, at airports, at ports of entry, also in the interior. Just yesterday here in San Francisco and other places on the West Coast, there were dozens of non-citizens ordered to report to ISAP, which is the Intensive Supervision Appearance Program. It's run by ICE, and they're supposed to report today and tomorrow. And that ostensibly is to take them back into custody. There's a big push, as the administration has said time and again, that they want to arrest and deport 1 million people in a year. And so they're using all sorts of tactics to try to meet that goal. So it's really incumbent on all of us to know how to file habeas petitions, know how to get it done quick, have templates, because things are happening, on a daily basis very quickly. And us as attorneys, we're on the front line to help these folks fight back against what Leah appropriately said is fascism and authoritarianism on a scale that, at least during my lifetime, we haven't seen in the United States. So with that, we've got a lot of material today in the slides. We won't cover each statement on the slides, but we will give you the most important information. And then, of course, you can take these slides with you after the presentation today. So first and foremost, immigration detention is civil, okay? It's not criminal. And there are only two reasons why civil detention would be assertedly constitutional. That's to prevent the risk of flight, and it's to prevent the community from someone who is a danger. So some seminal cases on that are Wong Wing, Carlson, Demore. I just want to flag, in most civil detention contexts, the government has to establish the necessity of detention by clear and convincing evidence, and usually before the person is taken into custody. It's unlike criminal proceedings or criminal arrests where post-deprivation procedures are appropriate. In most civil contexts, there has to be some pre-deprivation procedure provided, but that's not the case for immigration detention. As we'll discuss today, there are 4 immigration statutes that deal with detention. Several of them require mandatory detention because Congress has made the determination that certain classes of non-citizens should not be entitled to bond. And for the group of non-citizens who can be detained discretionarily, they have the burden to show that they are not a danger or a flight risk before they can be granted bonds. So it inverts the burden that's normally placed on the government to show the necessity of detention, and places it on the immigrant instead, the non-citizen, to show that they should be released. But despite all of this, despite the language in the immigration statutes, all law in the United States is constrained by the Constitution's mandates. And so the Constitution still applies to non-citizen incarceration, and we can rely on certain procedural and substantive limits on detention, as we will discuss today. I also want to flag one thing that's very important. Because the only 2 reasons that are permissible to be used for civil detention relate to flight risk and danger, civil detention can't be used to punish or to further deter future non-citizens who may be either intending to come to the country or already in the country. So this rationale is legally suspect, I would say completely unconstitutional, but it was embraced by the Attorney General in 2003 in a case called Matter of DJ. Fortunately, that rationale was rejected in a nationwide class action lawsuit. But this just, I think, is another example of the mentality of the government when it comes to non-citizens. They spare no expense. They'll go to great lengths to ensure what they view as, enforcing the law. And often what that means for our clients is that their constitutional rights are being violated, and it's incumbent upon us to ensure that that does not occur. So as I mentioned on the next slide, the INA's got 4 statutes that regard custody. Some of the statutes call for mandatory detention while others don't. So beginning first, Leah, if you could go to the next slide, please. Great. Beginning first with 8 USC 1225B. This authorizes the detention of non-citizens who are seeking admission to the United States or who are apprehended near the border. So common examples of people held subject to 1225B are asylum seekers who either present themselves at the port of entry and request asylum, or who enter the United States without documents but are apprehended shortly thereafter. It also applies to people who may come to a port of entry and be accused of having false documentation. Right now, there is litigation at the Ninth Circuit that challenges whether people who are apprehended after entering the border without inspection, but are actually apprehended inside the United States, where the demands of the Constitution apply, are entitled to bond hearings. There's been an expansive reading by some immigration judges of a Supreme Court decision called Jennings versus Rodriguez, that essentially says any non-citizen who has entered the United States without documents and never been what's called admitted is subject to 8 U.S.C. 1225B and therefore not entitled to a bond hearing. And that like turns on its head all of the precedent and interpretation of the law that we've had for decades. So the outcome of that litigation is still pending. As I said, it's at the Ninth Circuit right now. Folks under 1225B can be paroled from custody by DHS. So this is just an important thing to keep in mind. You can make parole requests for clients who are detained under 1225B. We used to see parole pretty frequently, either when an asylum seeker passed what's called a credible fear interview, or when DHS paroles someone out of custody to ensure family unity, etc. My experience, and I think the experience of most attorneys, is that under this Trump administration, the use of parole is effectively non-existent. There have been reports that the head of ICE needs to sign off on every parole request, which I haven't heard of anyone being paroled out. I'd love to hear others' views on that. But the idea that the head of ICE would have to sign off on a parole request is just not manageable, right? So effectively, what we're seeing is people held in custody in situations where they were previously paroled. And that leads to a slew of issues regarding, access to counsel, ability to prepare your case, the psychological harm that comes that comes about as a result of being subjected to confinement. And moving on, we've got 8 U.S.C. 1226A. This authorizes discretionary detention. It sets up the main framework for non-citizen custody and the process for requesting bond hearings in removal proceedings. As I mentioned at the first slide, for non-citizens detained under 8 U.S.C. 1226A, the burden is on them to establish that they're not a danger or a flight risk in order to get bond. 1226C mandates detention for certain individuals. So typically it's those convicted of certain crimes, whether it be a crime involving moral turpitude or two crimes involving moral turpitude, what's called a crime of violence. It also implicates those who are subject to terrorism-related inadmissibility grounds, and also implicates national security concerns, quote unquote. So when someone's held under 1226C, the immigration judge has very limited authority. The non-citizen can move for what's called a matter of Joseph hearing, and the immigration judge's inquiry is essentially limited to whether DHS is substantially unlikely to prevail on the charge of removal that would trigger the non-citizen's mandatory custody. I've done a decent amount of work in detention centers. Joseph hearings are beneficial for sure. But even when you have clear arguments that your client isn't subject to mandatory detention, you're dealing with an immigration judge that, again, is an employee of DOJ. They're typically former ICE prosecutors, and many times they worked at that detention facility where they're hearing cases now. And so often a Joseph hearing is really a mere formality and something that you do before you set yourself up to go in on a habeas in district court. Leah, if you could move to the next slide. So there are a variety of regulations that you should also be aware of when representing non-citizens in detention. I'm not going to go through each of these. They do sort of lay out some of the nuances in requesting bond or requesting parole from DHS. Two that I will flag is 8 CFR 1003.19. There's a provision there at subsection F that prevents an immigration judge from even holding a bond hearing where the person's presence has been deemed adverse to a foreign policy interest. Okay, so this is the regulation that was implicated in Mahmoud Khalil's case, Rumeysa Öztürk's case, Barakan Suri, Mohsen Madawi. And even though their detention fell under 1226A and it was discretionary, and in most instances they could have requested a bond hearing, there's this regulation that prevented the judge from even holding a bond hearing because their presence had been deemed quote unquote adverse to a foreign policy interest. There is a regulation at 8 CFR 1003.6. This allows DHS to invoke an automatic stay of a bond decision when they pursue an appeal of a decision granting bond. So for example, there's an individual who was arrested during the weeks of, ICE focusing on people for pro-Palestine speech and for pro-Palestinian advocacy, granted bond by an immigration judge in Texas, clearly not a flight risk or a danger, but DHS appealed within 10 days and invoked this regulation, which effectively stayed her bond grant, and she remains in custody. So, the immigration judge has limited authority. Again, once DHS invokes this stay under the regulation, the immigration judge has very little that they can do about it. And so there have been challenges to the regulation, that it's ultra-virus, that it's unconstitutional, etc. It's something that you can challenge on habeas. And I know at least within the Ninth Circuit, there has been some good case law developed on the automatic stay. For people, Leah, if you could go to the next slide. For anyone who does habeas work on behalf of non-citizens, there are seminal cases that you really should read and know about. This slide and the next lays a lot of them out. I'll just touch on a few. I don't think it's will be productive for me to give you a summary of each, and I think that the parentheticals are pretty good. But Zadvitas versus Davis is like it lays the groundwork for all non-citizen habeas work. So it dealt specifically with someone who had been ordered removed, was kept in custody beyond 180 days, and who could not be removed from the United States because there was no country willing to issue him a travel document. In that case, the Ninth Circuit or the Supreme Court held, there are limits to non-citizen custody. You cannot permit indefinite detention. At some point, detention becomes unconstitutional. And in that case, the inquiry was, has a person been subjected to what's called prolonged custody? There's no bright line for this, but the fuzzy gray line is somewhere around 6 months. And is their removal from the United States reasonably foreseeable? If not, then they should either be released or at least be provided a bond hearing before a neutral adjudicator who can determine the necessity of their continued confinement. Demore versus Kim, it dealt with a facial challenge to the mandatory custody provision of 1226C. The Supreme Court held, that mandatory custody is permissible for non-citizen detention during removal proceedings, but the opinion was based on bad data. The government told the Supreme Court essentially that removal cases end within a period of months, which is inaccurate. If you've been practicing immigration law for any length of time, you know that most removal proceedings, even in the detained setting, don't conclude in a matter of months. I mean, you might have a quick detention case that gets done in 6 or 7 months. If there's an appeal, it obviously gets extended. The Supreme Court, though, took the data from the government, said the concept of mandatory detention for a limited period of time is constitutional. Years later, the Attorney General explained to the Supreme Court that, the data we provided in Damore versus Kim wasn't entirely accurate. They submitted a letter and information to the Supreme Court that did nothing with that information. So it sort of rests on a false premise, in my view, but it permits mandatory detention. Nielsen versus Preop and Jennings essentially look at mandatory custody. Jennings also deals with 1225B and 1231. It essentially, like, both of them stand for the proposition that you can bring as applied constitutional claims to each of the 4 INA's custody provisions. And so that sort of like leaves us where we are now. You bring procedural or substantive due process challenges to the circumstances of your client's case. I'll touch on 2 more briefly. So Aleman Gonzalez, our firm was class counsel in this case. The case essentially dealt with whether non-citizens who are post-order and seeking either withholding of removal or have a motion to reopen pending and a stay in place can be detained for more than 6 months. The district court in the Northern District of California and the Ninth Circuit held that once you get to the 180-day mark, there must be a bond hearing provided to this class of non-citizens. The government sought cert at the Supreme Court, and Supreme Court granted cert and then raised a question that had not been briefed by either party, which is, can you sue on behalf of a class of non-citizens on habeas when you're seeking injunctive relief? Okay, so this was sua sponte. The parties had not briefed it. And ultimately what the case focused on at argument and in the subsequent decision is a limitation in one of the jurisdiction stripping statutes, 1252 F1. And so the Supreme Court there broadly held that class-wide injunctions for non-citizens in detention are impermissible. So it leaves the question of declaratory relief, what sort of protections you can get for a class of non-citizens, which we'll talk about later. The case now is back at the district court. The stay remains in place, so folks in the Ninth Circuit are still benefiting from the injunction. But at some point when we move forward with the litigation, if we move forward with the litigation and don't settle, we'll be presenting constitutional claims and then sort of figuring out the scope of declaratory relief for our class members. The final decision I'll just mention that's not on here, I should have added, it's Padilla versus Rumsfeld. It dealt with what's called the immediate custodian rule. And there's, for immigrant detention, oftentimes these detention facilities are in the middle of nowhere. Okay, and so there was good case law that permitted the non-citizen to sue the field office with jurisdiction over the detention facility. So these 2 locations often were in different districts. For example, I'll just talk about California. All of our detention centers now are in the Eastern District of California in McFarland and Bakersfield. But because ICE San Francisco still makes decisions on custody, we would file habeas petitions in San Francisco or anywhere in the Northern District of California. And the theory was GEO or CoreCivic or whatever private detention company is running that facility can't actually produce the person or release the person. So we would sue ICE in San Francisco that had that decision-making authority. For years, that was permissible, but slowly, I think, circuits are finding that Padilla versus Rumsfeld, which dealt with an individual detained at Gitmo, holds that you actually have to sue the warden of the facility where the person is detained. And so it makes no sense in my view, but the Ninth Circuit just went along with the reasoning of Padilla versus Rumsfeld. So at this point, we are suing the warden either in McFarland or Bakersfield, and our habeas petitions go to the Eastern District of California rather than the Northern District of California. This raises a lot of complications, the main one being that the Eastern District of California does not have that many judges or magistrates, and so habeas petitions take forever to be adjudicated there. So next slide. These two slides are dealing with the habeas statutes. So 2241 deals with your causes of action. Typically, it implicates procedural due process under the Fifth Amendment, so that the government can't deprive someone of their liberty without due process of law. Or substantive due process, that the Fifth Amendment doesn't permit the government to strip someone of their liberty without a hearing or to hold them in custody for an unjustified reason. 2242 just lays out the requirements of the petition. It's super formulaic, definitely form over substance. You have to verify that the facts laid out in the petition are true. It's either signed by the non-citizen or their counsel. And then 2243 deals with the procedure after filing, which I'll get into in a second. I think the most important, at least in my view, thing to point out in the habeas statute deals with the definition of custody. So habeas applies only to people who are in custody. But what does that definition actually mean? Obviously, it applies to people who are actually physically confined, so someone who's at a detention facility. But the Supreme Court has also interpreted the definition of custody to apply to people who are subject to a significant restraint on their liberty that is not shared by the public generally. So think about people who are released on an immigration judge bond. Leah, can you go to the next slide? I apologize. People who are on orders of release on own recognizance, maybe with an ankle bracelet, or reporting requirements to ICE, people who are post-order of removal, who are on an order of supervision. The basic principle for this is that those individuals are free from custody and exercising their liberty interest, but they're subject to a restraint that the public doesn't share generally. For folks who are in constructive custody, so subject to a restraint that's not applicable to public in general, there is the possibility of filing what's called a pre-deprivation habeas petition. So if there's a significant likelihood that they're at risk of being re-arrested without due process, you can go into district court on a habeas petition. I'm sorry, this is my beautiful cat, Koskias, who wants to be a part of the presentation. And you can ask a court to issue an order that no rearrest occur, absent the government either moving to reconsider the bond grant or establishing before a neutral adjudicator that detention is justified because the individual is a flight risk or a danger. Moving on now to 2243, the procedures. Next slide, please. I will not read these. I think you should know them, but I think my view is that courts essentially ignore the timing requirements that are laid out in 2243. And so oftentimes what you need to do in order to get a timely decision is file a motion for a temporary restraining order or a motion for a preliminary injunction that sort of emphasizes to the court the urgency of the court's intervention because your client is subject to unlawful detention. Moving on to the substance of the petition before I kick this over to Golnaz. Each habeas petition needs to have facts establishing the claim. You can also make a preliminary statement, like an introduction. I typically do that just to sort of set up the summary of the argument. You can lay out the legal background or analysis. That's optional. Then you must present causes of action or claims. And so typically in a habeas petition, you have at least two claims, I think nearly all the time, one in procedural due process, one in substantive due process, and you sort of lay out, based on the circumstances of your client's case, what exactly they are due under the law before they can be rearrested or subject to further incarceration. And finally, the last thing I'll say is when you file a habeas petition, make sure that you are conversant or fluid in the local rules of the district court. There are generally applicable federal rules of civil procedure. There are procedures laid out in the habeas statute that we just went through very quickly. And then there are local rules. And for example, in the Northern District, you have to file a proposed order as a PDF in support of a motion for a temporary restraining order, but you also have to email the proposed order in Word format to the judge's chambers. If you don't do it, it won't like kill the claim, but it will piss off the judge. And so you want to make sure that you're reading the local rules. Many judges have standing orders, and you want to comply with that too, because sometimes they want physical copies, etc. So always be aware of those local rules. If you're in a scenario where you need local counsel, always reach out to an attorney that practices in that district. They can give you invaluable information about unwritten procedures or how the judge acts, what their temperament is, etc. And oftentimes you may need local counsel anyway in order to file in that district court or appear on behalf of your client. So with that, I will pass it on to Golnaz that will talk about developing claims on habeas.
Thanks, Shawnee. I think you can go to the next slide, Leah. Thank you. Can folks hear me okay? Yeah? Okay, thanks. So in terms of thinking about what kinds of claims substantively it'll make sense to raise through a habeas petition, I think it's good to sort of start at like the bird's eye view level with an important framing question, which is in essence like what's harmful and unjust about the given circumstances, and what does the impacted person, your client, need and want? What do they want to accomplish? What do they want to avoid? So for example, they may well want to challenge the fact of their confinement. They may want to challenge some aspect of the conditions of their confinement. If they're at risk of removal under sort of speedy or summary circumstances, like removal without sufficient process, is that something that they'd like to sort of seek remedies for through habeas? And then I think another thing that's relevant to kind of bear in mind too is, who are the bad actors whose actions you're seeking remedies against through habeas? Is the bad action in the custody precipitating because of something that's happening with an agent of Customs and Border Protection, CBP? Or is the bad actions in custody precipitating from the conduct of an agent of Immigration and Customs Enforcement, ICE, within the interior? I think there can be differences in how you'd sort of frame arguments and other things within a petition depending on whose bad action you're going after. Another sort of relevant thing that's going to make a difference to how you sort of craft the substance of a habeas petition is being very cognizant, to the extent you're able to be, of what detention authority is applicable. So, Johnny sort of parsed for you the different INA provisions that govern different sort of categories of custody, or custody that applies to different categories of people. So there are given provisions that apply to people who are seeking admission at ports of entry or who are apprehended near the border. There are other provisions that are relevant to custody of folks within the interior during the pendency of removal proceedings, and still other provisions that apply to the custody of people who are subject to final orders of removal. And depending on which provisions are relevant, it's going to mean something for decisional law that will drive some aspect of how you craft a petition, the kinds of bedrock or landmark cases that Johnny flagged earlier and that folks should spend some time kind of on their own gaining familiarity with. I think another thing that's relevant to kind of assess is whatever detention authority applies under whatever INA provision. Is it a provision that allows for some sort of recourse or review on the part of an immigration judge? Johnny mentioned earlier that detention authority under the INA, no matter what category of person we're talking about, typically is either discretionary in nature or mandatory in nature. And that sort of speaks to whether IJ review might be available on the propriety of the custody. The reason why this matters for habeas is because of a doctrine that's called administrative exhaustion. Administrative exhaustion, it's sort of like a prudential doctrine. It doesn't really go towards like the core subject matter jurisdiction of a district court in habeas. But it's a prudential doctrine that district courts will look to in part in deciding how to manage their dockets and whether given claims that someone's raising through habeas could instead be brought first to the agency. And so in many instances, I think there are district courts who pay attention to this doctrine and may decline to kind of take review if they think that there's some opportunity to seek review before the agency, so the immigration court system, that hasn't yet occurred. I think different judicial circuits have sort of different decisional law on the exhaustion doctrine. And so that's something that you'd want to kind of gain familiarity with too. We're going to talk about what are common legal claims that can be raised through habeas. And downstream, Kyle is going to talk with you about some different kinds of obstacles, including sort of jurisdiction stripping and jurisdiction narrowing provisions that kind of impact what kinds of things a district court in habeas can or can't reach. Next slide, please. Oh, Leah, can you move to the next slide? Oh, thanks. Okay, sorry. No, you can go back to statutory claims. Sorry. So one flavor of legal claims that may be possible to bring through habeas are claims sounding in statutory provisions. So the INA provisions that define different statutory detention authority may give you a hook for raising some sort of a legal claim through habeas. Johnny referred to some landmark cases like Jennings and Preap. I would say a case like Preap is an example of a Supreme Court decision that kind of like takes off the table certain kinds of statutory claims that folks otherwise had poured a lot of energy into making with respect to the mandatory detention statute that Johnny referenced. 8 USC 1226C, he had let you know that that statute mandates the detention of enumerated categories of non-citizens whose removal proceedings are pending, including people who have qualifying criminal convictions. And it included language that sort of specified that mandatory custody is supposed to take place, quote unquote, when the person is released from the qualifying criminal custody that's antecedent. So people very creatively raised arguments through habeas on the meaning of when released. Like, does when released mean immediately after you're released from criminal custody? That was sort of the argument that was pressed, but that the Supreme Court ultimately rejected in Preap. That being said, though, there are still, I think, arguments that can be raised about the applicability of mandatory detention. There's a whole other body of law about like which kinds of criminal convictions under state law should or shouldn't trigger corresponding criminal grounds of removal and detention under the INA. And so I think that sort of terrain is ripe terrain for presenting statutory challenges to say, I am not someone who should be subject to mandatory detention, even though I do have a conviction for X under the laws of New York. That shouldn't be found to constitute a conviction that implicates the INA provisions relevant to removal proceedings, relevant to mandatory detention. Outside of statutory arguments about the legality of detention that sound in the INA itself, all of us know, like, you know, the INA is a drop in the bucket, and there are other federal statutes that are binding on federal officials, including immigration officials. And so one example is the Rehabilitation Act of 1974. It's a bedrock piece of law or legal framework that defines disability-related rights and remedies. And I think there are a lot of very, very creative potential arguments to press on the basis of the Rehabilitation Act that could do important work for clients who are in immigration custody who have qualifying disabilities. And some of those arguments allow for requesting release as a remedy. There's really good scholarship on this that we can refer you to after the fact, but it's just good to think creatively. Similarly, there's another legal framework in federal law, the Religious Freedom Restoration Act. So for clients in immigration custody whose religious freedoms are being abused, there may be angles under RFRA to press through a habeas petition as well, even if the remedies don't relate to the fact of custody. Next slide, please. So separate from statutory claims, there are a number of constitutional claims that I think are oftentimes the bread and butter of habeas petitions challenging the legality of immigration confinement. So at the top of the list in this slide, we've put arguments around procedural due process as required by the Fifth Amendment. Typically, those arguments amount to claims that whatever procedures exist to have custody reviewed by agency officials of one kind or another, those may be like review procedures that enable ICE itself or DHS itself to review custody. Those may be review procedures that enable immigration judges or other actors in the immigration court systems to review custody. If you can say something about the deficiency of those procedures through the lens of due process under the Constitution, then through habeas, you can ask for a procedural remedy, and typically that might be some sort of a hearing, even if it's before the agency, that offers better or less bad procedures. So Johnny had mentioned to you earlier aspects of bond hearings before immigration judges that are constitutionally suspect. So he mentioned, for example, that in a typical bond hearing before an immigration judge, it's the immigrant or the non-citizen who has the burden to establish that they are not a danger or a flight risk. And so I think, you know, there's absolutely a hook under the Fifth Amendment through a habeas petition to say having the burden placed on you runs counter to what the Constitution requires for someone in your position, subject to, as Johnny put it, civil immigration confinement as opposed to criminal confinement. And you shouldn't have the burden placed on you. The burden should lie with the government to substantiate or justify your confinement by clear and convincing evidence. So separate from procedural due process claims, there are also substantive due process claims. There are a few different flavors that we can offer by way of examples here. So Johnny mentioned to you earlier that the only sort of cognizable interests in civil immigration confinement sort of affirmed by the Supreme Court, actually in Zadvitas, are like preventing danger to the community or a risk of flight from immigration enforcement. So if you can allege and prove that there's an absence of those permissible interests, or worse, there is an impermissible interest driving the confinement. So for example, a punitive purpose, a retaliatory purpose, or a deterrent purpose, those should be bases for which you could raise a substantive due process claim on behalf of an impacted person. Separately, I think counsel access is something that I think fits under the auspices of substantive due process, although it has implications for procedural due process too. So just to sort of unpack that a little bit. If I am confined somewhere remote where I've been sort of purposefully separated from my counsel, that is something that could be asserted through habeas as a basis for challenging my confinement, because both under the INA and under the Constitution, counsel access is an element of due process to which non-citizens are entitled when they're challenging their removal, and detention is an aspect of the removal process, at least in this regard. Other kinds of constitutional claims that are possible to raise. So one that we've been seeing a lot of in the sort of Trump 2.0 era are First Amendment based claims. The examples, I think, are all ones with which attendees of the webinar are likely familiar, but cases like that of Mahmoud Khalil, Rumeysa Ozturk, Yoon Seo Chung, Mohsen Mahdawi, Laqa Kordia, and Dr. Han Suri, they're all cases in which, through habeas, claims are being made that there's a retaliatory purpose driving the confinement in violation of the First Amendment. There are also opportunities to raise equal protection claims. So if you have a basis to say that confinement is happening on a discriminatory basis, turning on a protected ground, that's something else that can be flagged. There are also other creative arguments that can be raised, some specifically relevant to the border context when you're challenging the behavior of CBP officials. You have the opportunity to raise very novel arguments under the Appointments Clause, but I think we can move on to the next slide. So other sorts of claims that aren't strictly constitutional are claims under the Administrative Procedure Act and the Accardi Doctrine. You're just sort of pointing out that the relevant entity, whether it's CBP or ICE, is violating its own regulations or sub-regulatory policy. There's the opportunity to raise the non-delegation doctrine, which is basically sort of pointing out what kinds of things Congress cannot delegate to executive authority. And then there are sort of non-core challenges that aren't really about the fact of confinement, but are about other things like removal, although bringing these challenges can be thorny in some different ways, and you can read the Thurasigium case to sort of see an example of why. Next slide, please. Okay, I think Johnny flagged to you the opportunity to bring pre-deprivation claims. This is just to say that if someone is released from custody, as Johnny put it, if they're still subject to a restraint on their liberty that the public doesn't otherwise face, through habeas, you can sort of make claims for why they should be entitled to at least some amount of pre-deprivation process before they're taken back into confinement. I think even absent those sorts of restraints on liberty, there may be the ability to still use federal district court litigation to seek pre-deprivation process. It wouldn't be through habeas, but just sort of food for thought. Next slide, please. So it's always important to be very thoughtful about what you're using habeas to seek relief for. We talked about procedural claims and the related procedural remedies, but there are other sorts of forms of relief that you can consider that will depend on the nature of the claims as well as the facts and circumstances at issue and what you know about the goals and concerns of your client. Those are listed on this slide, and we discussed them earlier. Release, access to counsel, changes in the conditions of confinement, enjoining a transfer from one facility to another, and putting a pause on unfair removal without sufficient process. Next slide, please. So Johnny has spoken a bit about some of the logistical aspects of gearing up to file a habeas. The time sensitivity is an aspect that I don't think can be overstated, especially in a climate where we know that transfers and risks of transfers are happening with alarming speed, especially in the context of custody that's driven by viewpoint animus. So for people who are at risk, having something prepared that can be ready to file at a moment's notice, while like their body is still within the jurisdiction of a district, maybe where the background case law is less bad, it's hugely important. For all of you who like may not be seasoned detention advocates or habeas practitioners, don't fret. There's opportunities to still kind of build out a team-based approach. So someone who can do drafting, someone who has maybe some bread and butter federal court experience, someone who at a minimum has e-filing privileges in the relevant district court, having access to resource counsel, folks who have the subject matter expertise on weedsy things like INA jurisdictional hurdles. If you build out a team-based approach can work well. Next slide, please. So in terms of the ideologically driven targeting that we're seeing under Trump 2.0, just a few quick things. Paying attention to whether the INA removal grounds at issue in the removal case and that are the basis for the detention authority that's asserted, do they have a nexus to speech? Do they not have a nexus to speech? That's something that may be material both to how you craft your claims, but also to anticipating defenses to arguments the government's going to raise. Otherwise, knowing about the nature of the detention authority asserted and so on. Next slide, please. So we've talked about First Amendment claims. The nature of them is like retaliation, viewpoint discrimination, or prior restraint, meaning that the custody is meant to chill further speech. There are so many good examples online that you can kind of read through to see the approaches taken. The good thing, I think, about the public nature of a lot of these cases is that the pleadings and briefing is posted online through the organization's websites. We can sort of share those links with you, but you'll see that in addition to First Amendment claims, there's substantive due process claims, procedural due process claims, and other claims. Next slide, please. Relief, I think, again, you can sort of review the complaints to see the nature of the relief sought. It includes things that speak to some of what's very time sensitive in this context, including immediate orders enjoining transfer beyond the district. Next slide, please. So you should know that you can attach to a habeas petition supporting materials. You don't have to do that. Some of this is a sort of sliding scale depending on the luxury of time that you do or don't have. But on this slide is listed some examples of the kinds of supporting materials that can be impactful. Next slide, please. So Johnny spoke to sort of how the district courts routinely blow and like ignore the timelines that the habeas statute itself sets out. And he flagged already some mechanisms through which you can try to up the ante to keep the foot on the gas pedal. You can do that by moving for an order to show cause, moving for an ex parte TRO and a PI, or interim release pending adjudication of the underlying merits of the habeas petition. Next slide, please. In instances where you get a good order through habeas and the government isn't abiding by its terms, oftentimes the habeas court retains jurisdiction to enforce its own orders, and you can move for that kind of enforcement. Next slide, please. We're moving it on now. I'm passing the mic to Kyle.
Hey, everybody. Thank you so much, and honored to be on a presentation with these panelists, and thanks so much, Leah. So I'm going to talk a little bit about the obstacles of getting to federal court. And can everybody hear me okay? Can you hear me, Golnaz? Okay, great. And so, well, I'm going to talk a lot about, and I'm going to try to move through these very quickly because we are a little bit short on time. But as we talked about, the Supreme Court and Congress has really worked together to constrict habeas relief in a lot of contexts. And so a lot of times they just like want to get you out of federal court. And they've done this a lot through the habeas jurisdiction stripping provisions in the INA. But I also included venue in this just because I think it's a way for the government to really control where a habeas is brought. And in doing so, can really restrict what kind of claims people can, if a habeas petition can even be really litigated. And Johnny already talked about Rumsfeld v. Padilla, which lays out the immediate custodian rule, which usually means that the warden of the facility is the only proper respondent, and it's the warden where somebody is being held. This wasn't expressly extended to federal immigration habeas petitions, and so circuit courts, it's a little uneven how this has been applied. Usually either just hasn't been reached by some circuits, but the Ninth Circuit recently had a bad decision in Doe v. Garland, where they did say explicitly it would have to be the warden. And so similarly in California, I practice in New York. And so many of our, historically, a lot of our clients were held, or just New Yorkers in general, were held in New Jersey, even though the New York City field office was the one controlling detention and made all the decisions. They were the only party that the U.S. Attorney's Office would talk to during litigation. We still were having to litigate these often in the District of New Jersey, and now more in Pennsylvania because of Moshannon Valley Processing Center, which is huge. And so we actually don't have a lot of litigation going on in New York, even though under traditional venue principles, that's where a lot of this litigation should be going on. And if you could do the next slide, Leah. And I've had unstable internet, so anytime if I have to like jump ship and somebody has to take over, please do so. And so while there is, I would say, Rumsfeld v. Padilla really constricted a lot of habeas jurisdiction, there are some good cases, and Ex Partendo, which arose during the Chinese Exclusion Act, said that once the venue is proper and has been filed in a district court, that court retains jurisdiction even after transfer. And so it seems that, well, we have had to deal with this for a long time, and venue's been something that I've litigated since I started litigating habeas. It seems like the government is just kind of taking the maximalist arguments about venue and also just transferring in a clear intention, with a clear intention of having like forum shopping. And so they are making pretty radical arguments right now. One that like, if you don't name the warden, that should be grounds for dismissal. So we often name still the ICE field office director who controls the case, since they should be really the immediate custodian. And at least in the Second Circuit, there's no law that says that you can't do that. There's really no controlling law because Rumsfeld v. Padilla explicitly said it wasn't extending to immigration habeas petitions. So we would still name the ICE field office director, and if a judge didn't agree with us, they would transfer the case, and just automatically the new court would substitute in the warden, and it wasn't really an issue. But now the government's trying to take a very formalistic approach, saying, no, it has to be dismissed. You had to have named the proper warden or it should be dismissed. And so what happens, let's say, in the case of Öztürk, when she was detained, she was in transit when the habeas was filed. And what the government was saying is that there was no habeas available until she is finally detained to where she's going to be detained for at least some period. So while her attorneys filed in the District of Massachusetts where she was arrested, all indications pointed that she was in Massachusetts. The online detainee locator said that they couldn't get any answers from ICE about her location, so they filed there. But it came to light that she was actually in transit in Vermont at the time. The government argued that the only proper respondent was the warden of the facility that she wasn't even at yet in Vermont. So essentially there was no habeas available for the time she was in transit. But luckily the Second Circuit has rejected that. And I would like to note that in the Alien Enemies Act context, JGG v. Trump, we have the full citation on one of the earlier slides. The government or the Supreme Court in an order said that this venue, these venue arguments, which are these like the holding in Rumsfeld-Padilla, which was specific to core habeas claims that just challenged detention, can now be extended to non-core claims, which generally would be have like traditional venue principles applied. If there is like an overlap, and if the claims challenging the non-core aspects, so like removal, in that case saying that Alien Enemies Act did not authorize removal of those individuals, even though they weren't challenging detention, because invalidation of the Alien Enemies Act against those petitioners would also invalidate their detention. They found that the kind of Rumsfeld-Padilla rule applied. And so those kinds of habeas petitions have to be brought in the jurisdiction where someone is held. Okay, next slide. Leah, could you go to the next slide? I think what the next slide is going to say is just talking about how important this is, because a lot of times, you know, people are detained very far from their counsel, from their family, where the evidence is held. And so in the last petition, it just kind of shows the difference, or the last slide shows the difference between the outcomes in how long prolonged detention claims take to be adjudicated, and at what point judges in different districts find that detention has become prolonged. And it's just radically different depending on which jurisdiction you're in. And as Johnny mentioned, sometimes it's not even about, you know, sort of the determinations of the judge, but just how quickly they can get to these petitions, because often these huge detention centers are in this kind of otherwise smaller districts where there's not a lot of judges. And so they just take forever to be adjudicated. And that can really just make relief meaningless, because some people take orders before you even get a decision. And so I'm going to talk quickly about jurisdiction stripping provisions, and these are INA provisions that really just push all these claims out of federal court. And so often judges are just really hesitant to look at any immigration case when it comes across their desk, because they are just so used to these jurisdiction stripping provisions. So especially in courts that don't get a lot of habeas, like immigration habeas petitions, they're often just inclined to just say no jurisdiction, this needs to go to a petition for review. So next slide. Leah, can we get the next slide? Okay, so I'm going to start, and I'm going to not run through all of these because they're very dense and it's just really kind of hard to get through. And so a lot of these you won't really raise in the initial petition, but really it's these are the sort of in the motions to dismiss or in the return that the government applies. So a lot of these will be in the replies where you really have to deal with these. But in some cases where you know it's going to be the central question of a habeas, it does make sense to sort of anticipate these arguments. And so specifically in the non-core, where you're not just challenging like present physical detention, if it's anything that has to do with temporarily pausing removal or other types of claims, you are going to want to sort of anticipate these arguments. So a big one is 8 USC 1252b9. And this says judicial review of all questions of law and fact arising from any action taken to remove a non-citizen from the United States shall be available only in judicial review of a final order. And so this, together with 1252A5, is a habeas channeling, or as a channeling provision that kind of takes all these questions about that arise from removal and channels them into the PFR. And so often the government's going to say any questions, arising from, which they read expansively, like arising from any action taken to remove a non-citizen, should only be brought into a PFR. And can I get the next slide? I think it's about Jennings. So luckily the Supreme Court, in kind of a surprising reasoning by Alito, had cabined this a bit and did not take the most expansive reading of it. And this was in a prolonged detention context in Jennings. So saying that 1252B9 cannot preclude review of prolonged detention claims because it would be very extreme. I think they used an example of, you can't just say any like injury that arises from removal proceedings has to go up into a PFR, because some of them just wouldn't be appropriate there. You would just never get review. I think particularly with the prolonged detention claims, it's true because you can't even argue this in front of an immigration judge at removal proceedings. You can't challenge your detention. And so if the only place you could bring this up is at a PFR, often, because of the way that stays work, non-citizens will have been removed by that time. They could have been removed for months or years before their PFR decision comes down from a circuit court. And so to think that you would be challenging your prolonged detention and all the injury that's happening every day of that detention only in a PFR is kind of this now or never claim. And so luckily the Supreme Court did cabin that provision a bit. And this is coming up lately in these First Amendment cases. And the Second Circuit just had a very good, the Ozturk case, decision, an opinion on this, and where the government was arguing that you can't bring up these First Amendment challenges to detention and habeas proceeding because it overlaps too much with the same kind of issues that are going to be brought up challenging removal. And so they have to go through a PFR process rather than habeas process. But the Second Circuit said, well, there's overlapping claims. It's still a collateral claim, and these detention claims can be brought in habeas. And so I think that opens up, especially kind of what Golnaz was talking about in some of the statutory claims to mandatory detention, that some courts said because they are these kind of overlapping legal questions about whether the mandatory detention provision applies, because it also has the same kind of legal arguments are implicated in removability. You can still challenge your detention through habeas, even though there are some similar claims, which I think is very helpful. Next slide. Okay, and 1252G is another big one. And this one often comes up when you're challenging, if someone is post-order and you're trying to kind of halt their removal because of some illegality in either the process or why somebody was being removed. And so 1252G says that habeas courts essentially will not have jurisdiction to hear a cause or claim arising from the decision or action of the Attorney General to commence proceedings, adjudicate cases, or execute removal orders. So that execute removal orders is often one that's litigated a lot, but this has also come up in recent cases, particularly for ideological targeting, about whether 1252G strips the court of jurisdiction over detention related challenges, because detention, the government would argue that detention is part of the process of commencing proceedings, and therefore a district court does not have jurisdiction under 1252G. But again, there is a surprising, otherwise very bad decision under Reno v. AADC, which said that you have to cabin those to only those exact 3 listed actions. So to commence proceeding, adjudicate cases, and execute removal orders. And so in the Ozturk case, the Second Circuit had said that, detention falls outside of these. On the next slide. I think it's 1252F probably, and Johnny talked about this, so I'm not gonna, it's about the, oh, actually, no, I'm sorry, that is coming up next. But 1226E also strips courts of jurisdiction to review pretty much like detention-related decisions, and so often that comes up in the bond context, and mentioned some of the legal arguments against the agency bond hearing procedures, which puts the burden on a non-citizen in a bond hearing. And you can file a habeas challenging that after after bond has been denied based on those unconstitutional process. You can ask for a new hearing where the burden is put on the government by clear and convincing evidence rather than non-citizen. And this is often an argument that the government is going to make, saying that that's kind of a, you're trying to set aside a decision on the bond from the IJ. But often, at least in our experience, a lot of district courts reject that. And I would say in both of these provisions, the other one, the second one, 1252A2B, little I, 2, is about kind of channeling some of these challenges to the asylum process and getting them out of the habeas jurisdiction. And what's kind of scary about this, these kinds of provisions is as like the IJs and the BIA have been just totally gutted, and many people have been fired. And it seems like we're just going to be getting worse and worse decisions out of the IJ and the BIA, not being able to challenge these, having like a clear path to challenge these decisions. Like, for instance, a bond hearing never in the way that the INA is written, never gets Article 3 review. And so I think we're going to have to be very creative in ways that we can get these questions in front of federal courts. And I do think that the way that the government is taking this kind of draconian and like maximalist approach to some of these, just the INA provisions and the way that they're executing, let's say the expedited removal statutes, for instance, or any of these, like the First Amendment violations, the ideological targeting. I think it's a new context where hopefully, at least in the lower courts, we're going to be able to challenge a lot of these jurisdiction stripping provisions, because it's just so clear that review has to happen somewhere. You can't just not have review. And so while I think we're going to get worse and worse agency decisions, hopefully there will be some openings in the district courts to show just how ridiculous these are, and hope beyond hope that maybe Congress will also realize that these provisions are just completely unjust. At least it lays bare that they are. Our next slide. And I think it's 1252 F, and so I'm not going to talk about that because that's about the class actions, and Johnny already covered that. Okay, actually it's not. This is 1252E, and this is the restriction of judicial, but there's not much on that slide, so I can just say it. The 1252E is a jurisdiction stripping provision about not having any judicial review of expedited removal orders. And I think a lot of people are having to deal with this right now, as the DHS and the DOJ are working together to sort of terminate people's cases who have been here less than 2 years and who are applicant for admission. And even if people are in regular asylum proceedings, they're terminating cases, taking people into detention, and then initiating expedited removal. And so I think this is going to be coming up a lot about what kind of judicial review you get in this context. And that case Thurassigum really constricted a lot of the opportunities to challenge this, and creates some pretty big obstacles. But I think, again, there's a lot of ways to distinguish that case. And I've already seen a lot of really creative challenges to these jurisdictional bars, particularly in the expedited removal context. So I think that's where I'll stop on the jurisdictional stripping provisions. It is like really dense and really hard, and I think it's just one of those things that at least these will be available for reference. And obviously there's like a lot of good cases that go into these, and you really have to like read them over and over, do all the, start with the statute as always, and then read a lot of the cases that sort of go into the nitty gritty of how these are applied. And then I put some appendix on just some seminal cases that are kind of the bread and butter under the burden shifting and prolonged detention cases are on the next 2 slides, but that's just for reference. And so I guess we'll do question and answer now.
Yeah, great. Thank you guys so much for so much information. I've put it in the chat, but I'll say it again. We will be sharing all of this information with participants after the training. It might take us a couple days to get it out to everyone, but definitely look out for these slides. And then I actually believe that from a Q&A perspective, Golnaz has been like really on top of it. So I appreciate that. I think most questions have been answered. There is one question that was put into the Q&A from someone named Gary. I just want to say I don't think we should answer this question in this context because it seems to be very specific and case related. And so I would encourage you to reach out to us separately and maybe we can provide you some guidance on this particular question. But I do think that in the context of post-deportation and a case that's been reopened, can maybe you guys shed some light on what that looks like in the context of what you've just discussed? The question is particularly in relation to permission to return to the US
Or seeking
to
somebody's
attend
return.
removal hearings.
Oh, Golnaz, do you want to take that? I'm happy to talk on it. Okay, so very good question, and I have a very frustrating answer. There is an old DHS policy that says if a lawful permanent resident was removed and their removal proceedings are reopened, DHS should facilitate, along with DOJ, their return to the United States. Sometimes they do, and sometimes they don't. It's been a mixed bag for me. For people who were removed and were not permanent residents, but get their proceedings reopened, in my experience, DHS and DOJ have never been helpful. And so we have filed habeas petitions to sort of, along with the complaint, to force the government to permit the person to physically come back to the United States. So like you would advise your client to present at the port of entry and file a habeas petition when they do, arguing that they should be paroled in or at least brought back into the United States. Many clients, at least those that I've worked with, don't like the prospect of possibly being held in custody while their reopened removal proceedings are litigated. So that presents a really difficult obstacle. And again, it's like pulling teeth, especially when your client was not a lawful permanent resident when they were removed. So the question is yes. I guess the answer is yes. You can file a habeas petition. I would recommend you couple it with a complaint and bring other causes of action as well. Essentially that they have the right to litigate the removal proceedings. They've been reopened for XYZ reasons, and so the government needs to facilitate their return. But it's never a straightforward process. If that didn't answer the question fully, I'm happy to expand on it.
Great. Thank you so much. And I would just say that, we'll try to also include some kind of contact information for people who did attend this training if any of these types of questions come out. But I will also end by encouraging people once again that if you're not a member of the National Lawyers Guild, you should definitely join our memberships because we have a lot of lawyers with a lot of knowledge, and these types of questions frequently come up in the context of reaching out to attorneys that you're connected with through the NLG. And so it's a really great resource as you continue down this path. I just want to thank everyone. I think we have answered all questions, whether it was we wrote an answer, again, thanks to Golnaz, or we provided answers throughout the presentation. I just want to thank our panelists once again for joining us and taking this time on a Saturday to give us this training, and everyone who also participated. We had 64 people here today taking time out of their Saturdays. That's really amazing. And if you are seeking CLE credit, we'll be reaching out to you separately to get payment for that credit and give you those certificates. And with that, I wish you a really great rest of your day. If you're going out into the streets today, please be safe and assess your risks, and hope to bring everyone together again for another training soon. Thank you so much.
If I could make a quick plug for
Sure.
NLGSF, I am on the
Of course.
board, and all the lovely people that I have the privilege of working with in conjunction with Leah and the NLG International put this on. I think in the last day, what we've seen happen in San Francisco with all these ICE check-ins and demonstrations that began last week, it's like a very clear example of NLG's role and how they can really serve to connect people and mobilize people. So far, I think the presence of NLG and other groups who have gone to ISAP and ICE to observe so far today has been really helpful, because to our understanding, neither office has yet opened. And I'd like to think it's because they don't want anyone to observe the illegality of what they were intending to do. And NLG played a critical role in organizing that. So, like Leah said, join. We want new members. If you're in the Bay Area, hit me up, or Hannah, or anyone else, and we'll plug you in.
Yeah, and I'll make sure to also include in the materials that we disseminate the websites for the National Lawyers Guild, both the national organization where you can get links to your chapters. And I will say that a lot of the on-the-ground work is happening through the chapter level. So this training was co-sponsored by the San Francisco Bay Area chapter. However, we have chapters all over the country. So on our national level, we also have a lot of committees. This is through the international committee, this particular training, but so yeah, so join the guild. Anyway, I thank everyone for joining this training today. I hope to connect with people individually or in a group soon, and be safe out there. Oh, Golnaz, did you have one more thing?
Yeah, I just wanted to, without meaning to put Kyle and Johnny on the spot, because I provided written answers in the Q&A, I just wanted to ask them to kind of double check and be sure that there isn't any answer they'd want to correct or supplement. Sorry, but no pressure, guys. I don't know.
I mean, I would say it looks like there was an answer or a question that was posed after we started like wrapping up. And so it's about the distinction between 1226A, B, and 1226C. And so I would say the slides kind of have like the differences between the three. And but I guess for the second half of the question is like, could you speak to like how habeas can be used to challenge prolonged detention? And I think we didn't go over it, but in that appendix slide, if you go over sort of like the seminal cases for prolonged detention, that would really show you which way you could take depending on which jurisdiction you're in. And I would like to also say that we did talk about templates, but we have not like disseminated them. So I run the habeas working group. It's kind of concentrated in like the Northeast, so Pennsylvania, New York, New Jersey. But we do have some like subfolders that go to like any jurisdiction. And so I'd be happy to share that when you, the link to that, Leah, when you share this out. And so that will have a lot of samples and some templates. And the bread and butter is like most of it is the prolonged detention, and then these burden shifted arguments, which are not, are no-go in some circuits, but we also have some about the ideological targeting, some airport issues, and hopefully we'll drop in some on this expedited removal piece. And also, if there's anybody who can share anything, we always are open to like adding more samples to the box folder. So we'll put some links in there to, in the resources.
Yeah, it's been sort of access restricted to date, and I think Kyle rightly and myself, like there's a desire to kind of be a little bit cautious in the stewardship of the repository, although it doesn't contain anything that's like client sort of specific or, you know, sensitive in that regard. But huge, huge, huge thanks to Kyle for consolidating some different repositories and for spearheading and leading the working group that she referenced focused on the East Coast. But yeah, it's a super great resource.
Yeah, and someone did ask how long you'll wait for the materials. We'll get those materials out within the week. We want to make sure we're including some of these other elements that we've mentioned that you didn't see on the slides in what we disseminate after the panel, just so that people have a really robust set of materials, both substantive and also you know, these tools that can be used in your practice. Just making sure we're providing as much as we can. And we'll also include, as I said before, some contact information if you have any particular questions where we could provide some answers. Yeah. So with that, anything else? Okay, great. With that, I am going to wish everyone a goodbye. Again, if you're going out today, there's a lot going on. Just, you know, stay safe, assess risks, and we're all in solidarity with you, and hope to bring everyone together again very soon. Have a great Saturday. See
Take
you.
care, everyone.